Good evening, ladies and gentlemen. My name is Leo Stoller, and I'm the Executive Director of Americans for the Enforcement of Attorney Ethics. This evening, I'm talking to you from Chicago, Illinois, our headquarters. AEAE is an attorney ethics watchdog group. We were formed in 1974 to watch attorneys carefully to see that they do not violate the code of judicial ethics. Throughout the years, we've noticed that there's a substantial high incident among many attorneys of not paying attention to the Code of Judicial Conduct. However, from time to time, we like to talk to you about various concepts in law and in the common law that you should be aware of. As part of our series of educating the public and one of the services we perform. Tonight, we'd like to discuss with you the concept of a bailment. Now, what is a bailment? Bailment is spelled B-A-I-L-M-E-N-T. And a bailment describes a legal relationship in common law where physical possession of property, a chattel, that's personal property. It's called a chattel. C-H-A-T-T-E-L. Now, many years ago, not that many years ago, but some time ago, women were considered chattel of men. In fact, in the 18th and early 19th century, women weren't allowed to own property. It wasn't until 1920 when they first got the right to vote. But anyhow, back to the bailment. A bailment is where one transfers property to another person who subsequently holds the possession of that property. A bailment is distinguished from a contract to sell in that the party who the property is transferred to never obtains ownership of that property. And what's an example of a bailment? We all experience it all the time, but we may not be aware of it. For example, we take our car to a valet. We give him the keys to the car. He parks the car. We go off to a restaurant or the theater. That's called a bailment. We expect to get our car back, and ownership is never transferred to that party. Likewise, a bailment is when we take our clothing to the cleaners. And we hand them our shirts or our jackets, and we need those clothing cleaned. We expect the cleaners to give us back our garments clean. That's called a bailment. Likewise, a relationship with a jeweler, where we might bring an item in to be repaired to a jeweler or have a stone reset or set on an engagement ring. We give the jeweler the engagement ring. That's a bailment. In addition, when we lease a car, we have an automobile which we have leased, didn't buy it, a bailment is set up. And an interesting concept in law occurs in that instance. Say, for example, a party who leases a car is unable to make payments on the lease. Well, if he doesn't return that car, he can be charged with theft. because the ownership of the car was never transferred to him. On the other hand, if you or I buy an automobile and we're unable to make payments because of our financial condition, we are not considered having stole the automobile. Of course, a repossession person may come out and repossess the car if he can find it. But when the party who buys an automobile outright, puts money down, doesn't pay for it, but puts money down on a contract, title is transferred to that person. And he's the owner of that car. Even if he hasn't paid for the car, he's not ever charged with theft if he can't pay for the car. But a bailment is created when we lease a car. Then if we don't make the payments, the sheriff's coming out and can arrest us. We have a situation where one of our members brought in a beautiful 18-karat white gold diamond cross to a jeweler, Michael J. Miller in Barrington, Illinois. A bailment was created. Mr. Miller took that gold cross into his store. The ownership of that gold cross was never transferred to Mr. Miller. Now, Mr. Miller, MJ Jewelers and Company in Barrington, Illinois, is refusing to return that 18-karat diamond gold cross. It's worth in excess of $10,000. If there's anybody who's listening to this video has any information on MJ Miller and Company in Barrington, Illinois, we would appreciate it if you would email it to AEAE at ldms4@hotmail.com. We're filing a complaint with the Illinois Attorney General's office, Lisa Madigan, charging Mr. Miller with deceptive trade practices, fraud, and theft. We are also preparing a class action lawsuit against Michael J. Miller and his wife, Nikki Flanagan. If there is anybody within the sound of my voice that has any information, may have been victimized by Mr. Miller, please email us that information. Remember now that a bailment never transfers ownership. A party who engages in a bailment, cleaners, jeweler, a valet service for automobiles, never actually receives ownership. It's not a contract where they own the item that they are trusted with. They're just given that item, and that item can be reclaimed at any time without notice. We appreciate your help in this serious matter regarding Michael J. Miller and his refusal upon notice to return a $12,000 cross to one of AEAE members.